this morning. Yesterday, we had a very intensive and thought-provoking session. But today we have other very challenging issues to discuss. So, as I mentioned yesterday in my presentation, my introduction, the promotion of judicial interaction techniques is one of the goals of our project. And I think that in the last few months, the concept of safe country of origin has shown how potential the judicial interactions techniques can be. Needless to say, I'm thinking about the preliminary ruling mechanism, but also I'm thinking about the disapplication of a national law, notably the national law listing the safe countries of origin when this national law does not comply when the EU law requires. As we well know, at the beginning of last October, with its CV judgment, the Grand Chamber of the ECJ set a milestone, I would say, in the safe country of origin rules under EU law. In the CV judgment, the Grand Chamber ruled some very important principles, and let me mention just a couple of them. Firstly, the court, actually I'm reversing a bit the sequence of the preliminary questions, but the court recognized the judicial review of the designation of safe countries of origins at the national level. So the court stated that the national judge must even ex officio verify the legality of the safe countries of origin designation. And notably, the national judge must assess whether a third country, which is listed as safe at the national level, meets and continues to meet the criteria set out for that purpose by EU law, notably the Annex 1 to the Procedures Directive. Secondly, the court stated that, at least for now, EU law does not permit the member state to designate only a part of a third country's territory as safe. So the member state, at least for now, cannot designate it as a third country as safe, introducing some exceptions, some territorial exceptions. And I think it is worth mentioning that the court reached such a conclusion by referring to several arguments. So first of all, the court referred to the wording of the Procedures Directive, notably the general and uniform safety requirement. But the court referred also to other important points. First of all, the court emphasized that the concept of safe country of origin triggers the application of a special examination scheme for the asylum request. Such an examination scheme has, as the court stressed, an exceptional nature. And due to this exceptional nature, such a scheme must be subjected to a very strict interpretation. Second, the court referred to the historical evolution of the Procedures Directive and its provisions ruling the safe countries of origin notion. And the Grand Chamber stressed that when the 2013 Procedures Directive was adopted, the EU legislator wanted to remove the option to declare a third country as a safe country of origin, introducing some territorial exception. So the court emphasized that, at least at the moment, EU law does not mention the option to introduce some exception. And I think that this argument the court referred to can be very relevant in order to deal with the other question which has been left open by this judgment. Indeed, as we well know, the CV judgment triggered a great discussion at the national level, especially in Italy, but not only. And at the same time, the CV judgment left open some very challenging issues, some very challenging questions, notably the possibility of declaring a third country as safe, introducing some exceptions for specific groups or categories of people. And we know that these issues is at the heart of several preliminary rulings submitted to the ECJ by the Italian and German courts. But before exploring the impact of the CV judgment at the European and national level, let's go back to the beginning of the story and to the origin of this judgment. And today, I think that we have the pleasure and the honor to have with us Martin Kopa. Martin teaches human rights law at Faculty of Law of Palachi University. But first of all, Martin is a judge at the Regional Court of Brno in Czech Republic, and Martin Kopa is the referring judge in the CV judgment. So thank you very much, Martin, for joining us today. And thank you, let me say, for provoking such a key judgment in the European asylum law. So, Martin, you have the floor for the next 20 minutes in order to provide us with the background of this very important judgment. Thank you.
Grazie mille, Marcella. Thanks a lot for this kind of presentation and an introduction. And by the way, I think we can skip my presentation because you've said all the important stuff. There's nothing left for me to say now. But I'm just joking. First of all, I'd like to express my gratitude for having been invited to this workshop. It really means a lot for me. So thanks a lot for that. Second, well, you've already mentioned what the CV judgment cost. And one of the reasons why I accepted to appear here today was that I really wanted to express my support to the Italian judges in the aftermath of the CV judgment, because what happened in Italy, that was I'll be blunt, I think that had nothing to do with the rule of law, had it. So I just wanted to express that and say that at the outset, that the Italian judges have my support. Because, I have a strong bond with Italy. Actually, I've already told Marcella that my mom, she emigrated to Italy, and she was a classic economic migrant from Czech Republic. And I spent my summers near Bologna in two little villages called Calderino and San Giorgio di Piano. So I've got a strong bond with Italy, and I was following really closely what happened after the CV judgment, and I'm with you guys. So I just wanted to say that at the very outset. And last but not least, before I start, I got sick last week, so I apologize if I will cough a little, but maybe I won't. I'll try to survive it. So let's jump into it. I'll just share my presentation. I hope it's going to work. I'm not sure if it's working now. Can you see my slides now or not?
Yes, we can.
Yeah, okay. So like Marcella said already, I'll try not to be too academic, but I'd like to tell you a story, essentially. Because, by the way, if I move the slides now, can you see the slides or can you see? No. Okay.
No, we see the full screen, so the videos for the moment.
Yeah, and now you can see the slides.
No.
No,
not yet.
You should open the window, I think.
Yeah, I did, but it's not working. I apologize. I just have a couple of
Don't worry.
Technical problems. If I press Can you see the slides now?
Yeah.
Okay, so I'll just keep the screen on the slides and hope that everything is okay. Like I said, I'll tell you a story, and I'll try to be brief in order not to prolong this over the necessary level. So if we go back to 2021, I'll be really blunt now. Basically, if you were an applicant from a safe country of origin, you didn't have a chance in the Czech asylum system. You know, the Czech law, we have a decree by the Ministry of Interior, which has a list of the safe countries of origin. And back then, until 2021, you didn't have a chance before the Ministry of Interior, and the main focus was on the rebuttable presumption of safety of a country. If you didn't rebut this presumption, which I don't know if of any cases where this happened before in 2021, then your application was manifestly unfounded. And even before a court, I don't know of a lot of cases where courts would have found out that the presumption was rebutted. So the situation of applicants from safe countries of origin was really bad, and they didn't have a chance. But then, in fall of 2021, I actually had a case that I think you have it in the booklet, in the bundle that you all got. And I had a case of a guy from India, and we have India on the list of safe countries of origin. And this guy did not rebut the presumption of safety. But actually, in the file, there was a COI, country of origin information on India, and you can see and read the relevant part of that report, which basically said that the police tortures people in India, and that there's a discrimination based on caste or religion in India. And there's one person I'd like to mention in that connection. I saw her with us today, and that is Karolina Michkova. She was my stagiaire, my trainee in my chambers back then. And she was actually the first person who came to me, and she said, "Look, Martin, isn't this kind of weird that India is on the list of safe countries, but it says in the report that it's not exactly safe?" So I thought, hang on, something's not right. We got to think this over. And like a week or 2 weeks after that discussion I had with Karolina, I've attended an online seminar for Czech and Irish asylum judges, and we had a presentation by Catherine Costello. I think you all know her. She's a brilliant Irish law professor, and she's an expert in international refugee law. And she had a great presentation, and she sent us her article from 2016 on the safe countries of origin. And man, that was an eye-opener, because for the first time, I've heard that I can actually review the designation. Okay, I can actually second guess whether or not a country should be on the list. So that was really important. And after that, I've made a judgment for the first time, I think, in the Czech case law, where I said that we have to shift the review in safe countries of origin cases from the rebuttal of the safety of presumption to the actual compatibility of the very designation of a country, a safe country of origin, with the requirements of the annex to APD, as Marcella said already. So that was a huge change. And so that was in fall of 2021. I think in November, this judgment was rendered. But then 2022 came, and as we all know, on the 24th of February 2022, the war started in Ukraine. So Ukraine was on the list of safe countries of origin. And well, I still can't believe it, but it was there until the 30th of September of 2023. So not even 2 years ago, for a year and a half, Ukraine, long after the war started, was still regarded as a safe country of origin by the law in the Czech Republic. But we had Ukraine on the list with the territorial exceptions that you can see on the slide. Basically, they consisted of Crimea and Donetsk and Luhansk. And I was thinking, look, aren't these territorial exceptions kind of weird? You know, because we also had Georgia with the exception of Abkhazia and South Ossetia, and Moldova with the exception of Transnistria. So I started reading in the expert literature, and as Marcella already said, well, like I said, she already said all the important stuff. I found out that the territorial exceptions were left out of the Asylum Procedures Directive intentionally. And you can find that out in the document that I'm linking over there. By the way, I'll send you the PowerPoints afterwards. So all the links that I have in there, you can they'll be available to you afterwards. So I had a couple of Ukrainian cases. So like a week or two, maybe after the war broke out, I basically have decided what was 2 years after in the CV judgment of the Court of Justice. I thought that the territorial exceptions are not permissible, that the country must be on the list as a whole, and the designation with territorial exceptions is incompatible with Article 37 of the APD. And I also thought that the courts have to take account of the war and of the circumstances which are not in the very application, in the complaint, that they have to consider them on their own initiative, proprio motu, as they say in Latin. But I must admit that this decision was criticized quite a lot by my fellow colleagues, and they didn't like it. They called me an activist, etc., etc. So I've also received a bit of backlash for that. And in March of 2022, we had a seminar at our Czech Judicial Academy where we were discussing all this, and we had a special guest, Professor James Hathaway, who joined us. I'm sure you all know him. He's one of my refugee law role models, and I just love him. So I had a debate, and sadly, I wanted to play you a video now of what he had to say on all this, but it doesn't work. But I'll send you the slides, and you can watch the video afterwards. And one of the questions that I've asked him, because I've read in his book and some other articles, is $1 million question: whether or not the whole concept of safe countries of origin is actually compatible with Article 3 of the Refugee Convention, which says that there can't be any discrimination on the basis of a country of origin. We have one case of the Court of Justice. It's a very old one under the previous procedural directive, and in a very specific Irish context. It's called HID, and you have the number in the brackets over there. So I'm not sure if it still applies to today's context. And Jim Hathaway was very unequivocal. He said that he thinks that the whole concept of safe countries of origin is actually in violation of Article 3 of the Refugee Convention. He was referring to a similar concept that they had in Canada, because he's Canadian, and it was called designated countries of origin. And Canadian Federal Court actually struck down this whole concept because it said that it was discriminatory on its face. And basically, Jim was stressing that decision-making in refugee law is about the facts on the ground and not about putting a label on your forehead and telling you where you belong formally. That shouldn't matter. And he said that judges should not be, limited in their review of the ground, of the facts on the ground, which are critical in assessing whether or not someone is a refugee. You can hear like 3 or 4 minutes in that video afterwards. Jim was very persuasive. So I thought, wow, this is weird, this whole concept of safe countries of origin. Something's got to be done about that. And in April of 2022, I've attended a seminar in Brussels of the International Commission of Jurists. I've met a couple of colleagues that I've also seen yesterday and today between the participants. And once again, safe countries of origin were discussed. And there was a guy from the European Court of Human Rights who had a presentation on that. And he was talking about Article 15 of the European Convention and the derogations. And he mentioned that, for example, Moldova made a derogation. I didn't know it back then. So I was thinking, wow, I've got a case of a guy from Moldova. And as you know, like I told you, Moldova is on the list. And probably it was there in Brussels that I've made the decision to refer the case to Brussels, to Luxembourg. I've also made one more reference concerning safe countries of origin, which I'm not going to talk about too long. It's a case called CD, which concerned the use of the concept in expulsion proceedings. Actually, our law allows for using this concept in expulsion proceedings. But the Court of Justice, as Steffi was criticizing the Court of Justice yesterday, Court of Justice has not responded to my question, and it said something totally different, which caused a collapse in our relation between expulsion and asylum proceedings in the Czech Republic. But that's a whole different issue. So on the World Refugee Day in June of 2022, I've referred the case. Marcella already described it pretty well. The first question was on the derogation, whether or not a country is still a safe country of origin if it derogates from the ECHR. Because, I've looked in the ASNAR protocol, and it said that all the member states of EU are considered safe countries of origin. But if they derogate under Article 15, they cease to be one. So I thought, well, if an EU country ceases to be a safe country of origin, well, then the third country can be a safe country of origin too. But I was wrong, as you know, because AG Emilio described that pretty well in his AG opinion, that the safe country of origin, these words in the ASNAR protocol, is something else than safe country of origin in the Asylum Procedures Directive. And as Marcella already said, the Court of Justice was pretty unequivocal that the territorial exceptions are not permissible under the law today as it stands. But we all know that the regulation, which will come into force next year, brings them back. And third, and I'll be honest, this question was the most important one for me, because in the application by the Moldovan guy, he said nothing about whether or not Moldova should be on the list. So I wasn't sure if I can review that on my own initiative, because the Czech administrative judiciary is still very formal, and the basic principle is that we are bound by what the applicant says in his application, and we cannot go over that in principle, which I'm still not sure if that's compatible with Article 46.3 of the Asylum Procedures Directive. So on the 4th of October last year, the judgment was rendered. You already know the answers. Marcella has repeated them perfectly. But there's one thing I'd like to tell you personally, because it all got quite emotional. Eugene Regan was the rapporteur, but I was watching the delivery of the judgment online on the website of the Court of Justice, and Koen Lennart, the president of the Court of Justice, suddenly gave a word to Sasha Prechal. And I don't know if you know it, she's a Dutch national now. She was because sadly it was her last day on the court on the 4th of October. She was a judge on behalf of the Netherlands, but she's actually a refugee from Czechoslovakia. Her Czech parents, they left Czechoslovakia after the Russians started occupying us in '68, and they moved to the Netherlands. And she read the whole verdict in fluent Czech. So I must admit that somebody probably started cutting audience in this very office where I was watching the delivery, and it meant a lot for me that Sasha Prechal was the one delivering this particular judgment. But I feel like I'm talking for too long, so you already know the answers. I'll jump straight to the post-CV development in Czechia. Like I said already in the beginning, in October of 2023, there was an amendment to the list of the safe countries of origin, and Ukraine was finally off the list. But Georgia and Moldova, they still are on the list, but as a whole. And I, once again, had a case where I was considering and deciding whether or not Moldova can be on the list as a whole. And in the Indian case that I was referring to in the very beginning, one of the principles that I've mentioned there in that judgment was that the COI in the file, that the report on the country, it has to prove that the country is safe. And here in the file, the report on Moldova, it said basically nothing about Transnistria, and it didn't prove that Transnistria was already safe. We all know that it's not, okay, but I was a bit formal maybe in that regard as well. So I've announced the decision of the Ministry of Interior and said that Moldova simply is not a safe country of origin from the perspective of EU law. And one last thing I'd like to say is that that's quite a lot of text in front of you now, but in Czech law, I'll try to simplify it. If you're an applicant from the safe country of origin, and you don't rebut the presumption of safety of the country, then the law says that Ministry of Interior does not even have to assess if you have well-founded fear of persecution, or if you'd face a real risk of the significant harm in your country. And I think that the CV judgment also, disqualifies that from the practical use as well, because it refers to Article 32 of the APD and says that the whole concept of safe countries of origin can only be used in case of unfounded applications from the perspective of the qualification directive. Sorry. So it basically says, and the Commission actually stressed that in the proceedings in the CV proceedings, that the concept of manifest ill foundation under Asylum Procedures Directive doesn't mean that the Ministry of Interior doesn't have to decide whether or not the application is founded on the merits. Okay, the whole safe countries of origin is only a procedural concept. To be honest, I'm not sure how that's supposed to work in practice. Maybe we can discuss that in the discussion, but the court said that too. And that's it. Grazie mille.
Grazie, Martin. Thank you, Martin, for your very interesting and complete presentation of the background of the CV case. And I must say that I saw some similarities between the evolution of the Czech and Italian system with regard the issue of the safe country of origin at the jurisprudential level. And I read the first case you mentioned, and thanks for saying that we indeed included this case in our booklet, and I found this case very interesting, and I saw some similarities between the issues raised under the Czech system and the issues emerged at the Italian level. And once again, having in mind the judicial interaction, I think that some of the solutions you have adopted have also been adopted by the Italian judges, and maybe some of them will refer to that during our later discussion. And thank you also for referred to a very important issue, I think. So the difference between the judicial review of the safe country of origin designation on the one hand, and the rebuttal of the presumption of security by the applicant. We know that according to the procedures directive, the applicant can rebut the presumption of security, submitting some reasons relating to his or her particular situation. But we have to emphasize that the rebuttal of presumption by the individual applicant must be distinguished from the judicial review of the safe of country of origin designation. These are two autonomous and different points. And you stressed that judicial review of the safe of country of origin designation is a procedural issue, and it has nothing to do with the applicant individual situation. Indeed, we know that in the CV case, the applicant did not come from the Transnistria region. So it is really relevant to stress that. And I'm highlighting this point because this is a point came up in the Italian debate too. And I think it is really important to emphasize this difference. And so, speaking about the Italian system, let's move to our next speaker, Madalina Moraru. Madalina is associate professor at the University of Bologna, but first of all, she coordinates our project as member of the Center for Judicial Cooperation of the UI, who leads our project. And so thank you, Madalina, for taking the time to present the Italian debate on these issues. So, Madalina, you have the floor for the next 20 minutes.
Thank you very much, Marcella, for the invitation, and good morning, everyone. I hope you can hear me well, because my experience with Gmeet is a little bit problematic. So
we can hear you perfectly.
Good. And of course, I feel quite a lot of pressure because I'm in a panel with two distinguished judges, experienced, who have actually made a mark on the development of EU asylum law. And, you know, as a scholar, we don't have maybe that kind of power to immediately see the impact of our work. So I definitely feel extremely honored to speak. And also I'm invited to speak on a topic that is very pressing. Unlike Martin, I think with the Italian preliminary references, we don't yet have a ruling from the Court of Justice. So it's a lot of talk about expected results and what may happen in the future. I also see in the audience there are some judges from some of the courts that send references for preliminary rulings. So I kindly invite also those judges to intervene if I miss something in my presentation. So just allow me now a few seconds to solve the technicalities and figure it out how to share my screen. Let me know if you can see my slides.
Yes, we can see.
Good, wonderful. On the other hand, I actually don't see you anymore, so that's going to be a little bit odd. But we will have some time to discuss at the end, and then hopefully I can see you again on my screen. So as mentioned by Marcella, the purpose of my presentation is to make an overview of the Italian preliminary references on the safe country of origin concept. There's been a few waves of these preliminary references, and they have, to a certain extent, a common legal background, but they also present differences in terms of the actual national legal framework that is contested, and also in terms of the actual questions regarding the clarification of the safe country of origin concept. The key provisions that are at issue in these references from the point of view of EU law are those that were also mentioned by Martin in his presentation, so Article 36 to 38 from the recast Asylum Procedure Directive. And in total, so far, of my knowledge, there are 6 preliminary references that have been submitted in 4 waves. The first wave is from the Tribunal of Florence. There are 2 references which concern a specific national provision. And then the other 3 waves, they have in common that they refer to the newer legislative provision where a safe country of origin list was introduced. But as you will see from my presentation, they have also they address different aspects of the procedure. The time frame is quite limited in the sense that they were submitted between May last year and January this year. And in terms of the legal background, perhaps Italy is surprisingly a bit different from other member states in the sense that they adopted a list of safe country of origin quite late in 2018. And for instance, just to give you an idea, in 2022, there were already 19 member states that had adopted lists of safe country of origin. The approach of Italy was to first include this list as part of a ministerial decree, so an executive act. This is not surprising because actually the majority of the member states adopt this list by way of executive order, so not in a legislative provision. And initially there were 16 third countries that are included in the list. These were broadened by a later degree to up to 22 third countries. And this decree was actually at issue in the first wave of preliminary references. Then in October last year, these were replaced by way of a law decree. So this time is a legislative measure. And one of the aims, like stated aims, was to bring the national legislation in line with the judgment of the Court of Justice from the Czech references for preliminary ruling. And so they excluded those third countries where territorial exception existed, such as Cameroon, Colombia, and Nigeria, and the total number of countries reached 19. However, if we look at the evolution of this list, Tunisia and Bangladesh have always existed there. If we compare the number of asylum claims in Bologna and Florence, which are two of the courts that have sent preliminary references, these are actually the countries from most of the asylum claims originate from. And so this is not a new argument. It has been put forward also by Catherine Costello that if we look actually at those countries that we see in the national list of safe country of origin, these are actually the countries from which the majority of asylum claims originate in the member states. So the legitimacy of drafting this list is challengeable. In short, the main legal issue is the compatibility of Italy's designation of safe country of origin with the provision of the recast asylum procedure. In particular, the references challenge whether third countries can be designated as safe when there are exceptions for certain at-risk groups. So now we see, as mentioned also by Marcella in the introduction, that the specificity of the Italian references compared to the reference set by the Brno court is that the focus is on personal exception, so not necessarily territorial exception, as that has already been settled by the Court of Justice, but personal exceptions regarding particular groups. And also the difficulty to verify actually within a very particular time frame, which is that of the accelerated procedure, whether there are potential violation of the principle of non-refoulement as regard these groups. Also, the national courts ask whether they have an obligation to ex officio assess the designation of a third country as being safe, whether there is an obligation for the national judges to disapply the national law that is incompatible with the recast with the recast procedure directive. Of course, for EU lawyers, I think this question is not, it's obvious the reply to a certain extent, but we have to look at the political, so legal political context of these references, because there was a lot of backlash from the executive and politician regarding the role of Italian courts in asylum, and particularly the fact that they were striking down national legislation. And in addition to that, at least the background during the first wave of references was that there was, to a certain extent, divergent case law on how to tackle the assessment of safe country of origin. So I'll start now to discuss the references one by one, starting with the first ones that were sent by the Florence Court. And we see that this particular reference refers to the ministerial decree. And in particular, it focused on two countries that were on that list, and that is Nigeria and Ivory Coast. For Nigeria, the Italian legislator identified numerous categories of excluded persons, so up to 11 risk groups. But also the specificities of this reference is that for Nigeria, there were exceptions, both personal and geographical exclusion, in particular the northeast part of Nigeria. And just to give you an examples, the types of groups that were excluded were internally displaced people, members of the Islamic movement in Nigeria, so groups that were very difficult to actually assess and that required time, which within the accelerated procedure, it's very limited. And so the question regarded actually the combination of these two exclusion criteria, personal and geographically, and whether they effectively prevent the rapid identification of the person to whom the accelerated procedure apply, and the derogation from the ordinary procedural regime. It also raised concern over the procedural fairness and the effectiveness of legal remedies. The second wave of references, these were sent by the Tribunal of Bologna, and we see already that they referred to the newer legislation, so the law decree, which, although it diminished the number of countries third countries that were on the list, there were still important personal exclusion for some of these countries. And again, it challenges the designation of safe country of origin for those countries where there are forms of persecution or exposure to serious harm related to a single social group that is very difficult to identify, such as the LGBTQ persons or ethnic or religious minorities. And also, again, it inquires about the obligation of national court to disapply national laws that are conflicting with EU law. The third wave, which is submitted by the Tribunal of Rome, addresses a slightly different question, which is a procedural question and a procedural requirements on how you actually arrive at selecting a certain third countries as being safe. And so it questions whether the legislature can designate safe countries without disclosing assessment resources. It also considers the impact of opaque designation on judicial review and asylum seekers' rights, and asks about the power of national courts to use independently external sources for assessing the safety in a particular third countries, because nowadays the UAA publishes quite numerous reports on safety regarding particular third countries. And if we look at the various lists adopted by the member states, they're not all in line with what the UAA is issuing. So I think these are important questions to clarify, and that will help national judges across the EU. The first wave, the last one, is from the Tribunal of Palermo. Again, it looks at the latest legislative provision and questions the legality of designating a country as safe if large population groups face risk. And also it examines the accelerated procedures fairness in handling these cases. As regards expected outcome, I think the contribution of the Court of Justice is essential because it adds to what it has already said in the preliminary reference originating from the Czech Republic. And it clarifies the limits of national discretion when we designate third countries as safe. If we look at what the Court of Justice has said in the Czech case, we might think that it will take a similar approach also to personal exception. However, it remains to be seen the extent of its formulation, because I think that has the potential to make an impact also for the future in regard to the future asylum procedure regulation, which has already been mentioned by Martin, that it will actually allow for exceptions based on personal grounds. So the contribution of the Court of Justice is essential, not just within the framework of clarifying the current EU asylum framework, but also for the future, that is from 2020, mid of 2026 onwards. If we look at the formulation in the regulation in Article 59.2, we see the formulation refers to exception for specific parts of its territory or clearly identifiable categories of persons. So this formulation of clearly identifiable is actually also at issue in the references sent by the Italian courts, because they were claiming that some of these groups are actually not clearly identified. It takes time, which within the framework of accelerated procedure does not, it's not possible. And one final remark before I don't know if you can still
you can
me,
take some moment.
Okay. A final remark refers to the use of judicial interaction techniques, in particular the reference for preliminary ruling. I think this is a tool that is extremely important for national courts, but also for the development of EU asylum law. We've seen within the context of today's discussion, and probably also yesterday, that Article 267 is generally used by national courts as a source of interpretation of EU law and establishing the conformity of national law with EU law. But I think if we look at the future, especially once the pact will be in force, what we will see at issue is the validity of the very provisions in EU law, in the EU asylum law, with the EU Charter and the Geneva Convention. So I think we need to consider, as legal experts, also this possibility of using Article 264 in order to inquire and invite the court to actually review the validity of EU legislative provisions. And Martin has rightly pointed out this discussion opened by James Hathaway regarding the use of the very concept of safe country of origin and its compatibility with Geneva Convention. So thank you very much for your attention, and I look forward for questions and discussion. And again, I reiterate my invitation to the Italian judges to intervene. I've seen at some point Luca Miniti, so feel free, Luca, to intervene. Thank you very much for your attention.
Thank you, Madalina, for this excellent overview. By the way, I don't know how you were able to sum up such a complicated debate in such a short time, so congrats on that. Let me just add another piece to the debate, just to underline that after the CV judgment, some Italian courts decided to solve the conflict between EU law and national law, notably the national list of safe countries of origin, by the way of disapplication, so disapplying the national list. And I don't say that because, as many people know, I'm a supporter of this application, but just because I think having in mind the judicial interaction techniques, it is interesting to consider also this solution, and to consider that the same issue can be solved by taking different ways. For sure, the different solutions can depend on the specificities of the procedure. So, for example, the way of this application was taken notably by some courts, which were asked to validate the detention of asylum seekers coming from a safe country of origin. So the kind of solution that national judge decide to adopt can obviously depend on the procedure the judge is asked to make its review. And thank you for Madalina for this important reference to the preliminary ruling mechanism, notably having in mind the new pact and the this for our debate, the new regulation procedures, and so the importance that the preliminary ruling referred now by national judge can have a kind of impact also for the future. But we are a little behind schedule, so let's move quickly to our next speaker, Philipp Herrmann, who is a judge at the Administrative Court of Berlin. And notably, Philipp sits in the chamber of the court, which last November, at the end of last November, submitted a request for a preliminary ruling seeking clarification on the admissibility of the exclusion of certain categories of persons, so the great issue left open by the CV judgment. So thank you, Philipp, for being with us today, and you have the floor for the next 20 minutes.
Mm-hmm. Thank you, Marcella. Good morning to everybody, and thank you for your invitation to this interesting platform. I want to start my presentation immediately. I hope it works. I share the window and start it. Can you see it? Can you see the presentation?
Yes, we can.
Okay. I want to give you a short overview about the pending case C839/24, which was lodged there on December the 9th, 2024, and which was named by the court Casamance, just because the Senegalese plaintiff was born in a region of Senegal called Casamance. My name is Philipp Herrmann, and I am the presiding judge of the 31st Chamber of the Berlin Administrative Court. So this is the overview about my short lecture. I first want to give you a short summary of the questions we submitted and their background. And then I want to talk about the concept of safe countries of origin in German and European law. I will have a short look on the sources of the law. And because Marcella asked me to talk about this topic, I want to talk about the power of national judges to review national acts listing the safe countries of origin and the jurisdiction we can find about these topics. And finally, I want to go into detail about our preliminary questions that we submitted to the ECJ. First, a short summary of the questions and the background. As part of the asylum application procedure of a 26-year-old Senegalese citizen, the Berlin Administrative Court has submitted several preliminary questions to the Court of Justice of the European Union to complete jurisdiction on the classification of a third country as a safe country of origin. Senegal is classified by Germany as a safe country of origin, and as a result, Senegal asylum procedures in Germany are carried out according to special rules. Among other things, there is an individually rebuttable presumption that there is freedom from persecution and inhumane or degrading punishment or treatment in the country of origin. But in some other member states of the European Union, Senegal is not or no longer classified as a safe country of origin. For example, in France, Senegal was delisted by a judgment of the Conseil d'État in the year 2021, just because of risks for one group, the group of homosexuals. And in the Netherlands, it is on the list, but with group-related exceptions for LGBTQI applicants and the people claiming criminal prosecution or discrimination. I want to talk about the situation in Senegal as we find it if we read about it. Around 25% of girls and women between the ages of 15 and 49 are victims of genital mutilation. Some regions of the state have the highest prevalence rates in the world. In these regions, over 90% of all women in the respected region are victims of the genital mutilation. Also, a problem is forced marriages, especially of minors. It is widespread in rural areas, despite the legal ban. Then we can find a large number of children, and the estimates range from 60,000 to around 100,000 children between the ages of 3 and 15 who are sent to Quranic schools by their families, the so-called Talibé children, where, in many cases, they are abused for begging on the streets. And then, as I mentioned, there's a problem for LGBTQI people. Same-sex sexual acts are punishable by imprisonment of up to 5 years or a fine in Senegal. And religious communities show no tolerance towards sexual minorities, and these people are discriminated against in society too, not only by the state but also in society. And then another group.
Sorry, Philip, I beg your pardon for
Yes.
interrupting you. We cannot see your slide scrolling, so we just see the first one.
Okay.
You should move
Okay, that's a problem.
during presenting. Sorry.
It's still okay. I try another method. I can
Otherwise, I can share for you.
I can share the whole monitor. Can you see it now?
Not yet. Okay, now.
No.
Okay, let's try. Okay, let's try to move to the next one. Okay.
The situation.
Now it's working perfectly. Thank you. Sorry.
Yeah. Thank you. So the situation in Senegal For the last group I mentioned is also critical, although the Senegalese constitution provides that all defendants have the right to a fair and public trial. There are problems with arbitrary arrest and prolonged detention, and this still remains a concern. So our court, the Berlin Administrative Court, has submitted several preliminary questions to the Court of Justice of the European Union to complete its jurisdiction on the classification of a third country as a safe country of origin. And the ECJ recently decided, as was already mentioned before, in October 2024, that country may not be classified as a safe country of origin if parts of its territory are not safe. This is the territorial aspect, which is now clarified, but it is still unclear whether a third country may not or may be classified as safe if a group or certain groups of people are not safe. And that is the topic we want to get answers from the ECJ. So now I want to talk about the German constitution and the national law. This is really a lot of text, but I marked the paragraph which is important. First, you can see here the German Constitution, Article 16a. We have found the concept of safe countries of origin in the German Constitution since 1993. At that time, this Article 16a was created, and the paragraph 3 contains the regulation regarding the safe country of origin. And the concept is implemented by Section 29a Asylum Act in conjunction with the list of safe countries of origin in Annex 2 to the Section 29a Asylum Act. And the following countries are on the list. I want just to talk about not only Senegal, but also about Georgia and Moldova, because these countries were only added in the year 2023. They're quite new on the list. I guess they came on the list when the Czech case was pending at the ECJ. But now we have the judgment of the ECJ, and nothing has changed in the list since this ECJ ruling on October the 4th. I wonder if it is different in the Czech Republic. This would be a question to Martin Kopa. Did the country change the list after the judgment in Czech Republic? You can answer later.
Yeah, well, I can intervene now.
Yes.
The Czech Republic, they've changed the list even before the judgment, like in October 2023. But after the judgment, nothing changed.
But they changed it before the judgment in a way that the whole country is considered to be safe.
Yeah, they've left. We only had 3 countries with territorial exceptions, Ukraine, Georgia, and Moldova. Ukraine was off the list, but Moldova and Georgia are still on the list as a whole.
Yes, that's what I thought. Thank you. So why are these 2 countries still on the German list? I found some arguments. One argument was given by the government, who was asked in the parliament, in the Bundestag, and the argument given by the government is, they say, the ECJ has decided that member states are not allowed to designate just a part of the territory of the affected third country as a safe country of origin. However, the German law classified the entire territory of the Republic of Moldova and the Republic of Georgia as safe. So I doubt if this argument is a good one, but it was given by the government. And then I heard some other arguments given by an official of the Federal Office for Migration and Refugees, why they still enforce this law. And I heard it by a colleague who met this official on a conference. And he said that law is law, and the law is not evaluated by the Federal Office for Migration and Refugees, and but it is applied. And another argument, which is also a weak argument, I think, is that the ECJ ruling affects Moldova, but not Georgia. Okay, next topic I want to mention, that there is a quite old national jurisdiction about the topic, and this jurisdiction of the German Federal Constitutional Court inspired us to ask our questions, or how to ask our questions to the ECJ. And also it was, of course, an inspiration for us to read about the Czech questions and answers. And also it was inspiring for us what the Conseil d'État in France did with Senegal as a safe country. And this national jurisdiction is old. It is from the year 1996, and it said, for a state to be designated as a safe country of origin, security from political persecution must exist nationwide and for all groups of people and population. And then there's another thing they talked about. It is that there is a scope for assessment and evaluation for the legislature. And this means that the court is not allowed to make the decision on its own. The decision is made by the legislature, and this has a scope. So next thing. Marcella asked me to talk about the power of national judges to review national acts listing the safe countries of origin. And if you see what our national system, how our national system works, this power is limited, because in Germany only the Federal Constitutional Court has the authority to reject federal post-constitutional laws as the Asylum Act. So the way to do it is that the administrative court, first instance court, must suspend the procedure and submit the question to the Federal Constitutional Court, and only the Constitutional Court can answer the question if this federal law violates the basic law, the Constitution. Nowadays, the national fundamental right to asylum is largely overlaid by union law today. So now a parallel regime exists to the German constitutional Article 16a. And the Asylum Act implements, of course, the EU directives and regulates both procedural issues and substantive issues of international protection. And this legislation that implements an EU directive must be measured against union law. So the power of national judges to review national acts listing the safe countries of origin that do not comply with EU law criteria is now a little bit stronger than before, what I mentioned before. And I first want to show how it is in proceedings for interim legal protection. In these cases, we can an application rejection only applies if the circumstance is taken into account, the circumstance that there might be a question in the main proceeding that will probably require a referral to the ECJ. And then in the main proceeding, if we have doubts or questions, we submit preliminary questions to the Court of Justice of the European Union, what we did. And if it is clear or clarified, we have the priority of application of the union law. In the case of direct collision, the member state law becomes inapplicable. And we can do this as a first instance court if the question is clarified. And there is a jurisdiction that I mentioned of the ECJ, the judgment of October the 4th, that a third country may not be classified as a safe country of origin if parts of the territory are not safe. I just want to talk again about the priority of application. The priority of application must be observed by all member state authorities, including the administration, and it means that in the event of a collision, any conflicting provision of state law becomes inapplicable, regardless of a previous preliminary ruling. The application priority prevails in both cases, in the direct collision case and the indirect collision case. In the case of a direct collision, union law and member state law impose contradictory legal consequences, and the member state law then becomes inapplicable. Now, I want to go into the detail of our preliminary questions. The first question you can read here. With this first question, our court asked whether Annex 1 should be interpreted to mean that for a country to be recognized as a safe country of origin, there must be comprehensive security for all demographic groups or categories of individuals. This implies that it might be detrimental if only individuals from a specific group or category face persecution while others outside this group do not. And we think that a third country can be designated as a safe country of origin, provided it is safe for all groups or all categories of person, but not if perhaps we think that it cannot be designated as safe even if one group is in danger, in risk. But of course, we don't know it for sure, so that's why we ask this question. And the second preliminary questions is here. You can see that we seek clarification on the concept of a group. We want to know what is meant by such a group. Does it also include regional or local groups with small number of members? How many members must there be that you can tell it is a group? And also, when does a group suffer persecution? So it is just, or in what cases the group-related probability standard needs to be clarified, and perhaps it's also a question about the required group-related relative or absolute quantity of corresponding events. The third question is just how it should be interpreted otherwise if the question 1 is answered in the negative. And with the fourth question, we asked about if national authorities have a scope for assessment and evaluation, which is only subject to limited judicial review. And then the fifth question is about what does a judicial review refer to if question 4 is answered in the affirmative. So, thank you. I think I am ready. I finished. Yeah.
Thank you, Philipp, for providing us with this overview of your preliminary ruling and more generally your system and the safe of country of origin concept under the German law. I found very interesting and fascinating, I would say, the difference nuances that the issue of the personal exception admissibility can take in the different preliminary ruling, the different preliminary question that the Italian and the German courts submitted to the ECJ, and your presentation allows us to grasp this difference. So thank you. Thanks also for mentioning this very interesting point concerning the scope of the judicial review on the safe of country of origin designation, and notably the limited scope that the administrative courts have under the German system. And I'm wondering, I'm thinking that maybe this point can raise some issues about the relationship between EU law and national law, and you mentioned that, you rightly mentioned the principle of primacy law, and notably, I'm thinking about the answer that the ECJ gave to the third preliminary question in the CV judgment. The court stressed that the judicial power to review the national designation of safe country of origin is based upon the right to the effective judicial protection. So the Article 47 of the Charter and Article 46 of the Procedures Directive, and the court stressed the direct effect of this provision. So I think that this point must be kept in mind when we dealing with and discuss the issue, the preliminary question you submitted to the ECJ. So thank you to all our speakers for their very interesting intervention. I think that you provoked several question in our audience, notably among the Italian judges, lawyers, and academics.